Hello, Vermont. I am Jill Martin Diaz. My pronouns are they, them. I'm an immigration attorney and the executive director of Vermont Asylum Assistance Project, and I will pass to Emma.
Hi, everyone. I am Emma Matters Wood. My pronouns are she, and I am an immigration fellow at Vermont Asylum Assistance Project. Passing to Liz.
Hi, my name is Liv Barrelson. My pronouns are she, her, and I am the executive director at the Community Asylum Seekers Project in Brattleboro, Vermont.
Thanks so much for being here, folks, and agreeing to record a little video podcast talking about the USCIS registration requirement. I'll just give a little bit of a content note. We are talking about a really old, draconian, harmful part of immigration law that uses the A word to refer to non-citizen people. And that's a word that's written into the statute. It's very harmful. We won't repeat it here in the video, but you will be seeing it on screen as you do now. So just be sure to take care of yourself as we go through the presentation. The purpose today is to have a discussion about what is this new registration requirement? What does it mean? Who does it affect? What are some common misconceptions people have? Liv will be leading us through the discussion, and based on questions that she's hearing in her community as a community service provider serving non-citizen people in Southern Vermont. And Emma and I will kind of, chew on some of the issues. We welcome Liv to jump in with perspective, your case stories, any follow-up questions. We imagine this conversation will last probably about 10 to 15 minutes. And we will be circulating it on our YouTube channel, through our newsletter, and on our educational website, vaapvt.org. So without further ado, Liv, please take it away.
Yeah, so we have a lot of people who've been asking questions about, do I need to register if I'm in court? Do I need to register if I've had my biometrics, but I haven't received my work authorization document yet? So it would be really helpful, I think, if we could go over who doesn't need to register.
Yeah, so individuals who, by the language of the registration requirement, do not need to register are those who have their EADs already, those who have been registered or fingerprinted through their application for a visa, who've been here for less than 30 days, and who hold certain types of visas. Additionally, individuals who have been docketed with the court at this point, so who are in court, are, I believe, currently exempt from the registration as well.
Okay, so if someone is in removal proceedings and they know that they have a court hearing, they do not need to register.
That is my understanding, though. I've seen from what Jill has shared on the screen that does not appear to be written on the AILA guidance.
Yeah. So there's like a little bit of conflicting guidance, and that confusion is by design, right? So like to take a step back, right? To take a step back, like I'm curious if actually we can pause a second and think about like, where does this come from? Is this like some new law? I thought that the president can't make new laws. Like, why is this happening, and why is this happening now? Is this allowed to happen? What like, Emma, can you just give us a little bit of a snapshot of why this is happening and why we're all so confused?
Yeah, so this is a pre-existing law to sort of go to the initial part of that question, that has been defunct for a long time and has been dredged back up. I would say in large part to cause chaos and confusion and frighten communities. And so far, it's been really successful at doing that, which is deeply unfortunate. I want to be clear that when I was speaking earlier about individuals who are quote unquote required or not required, that's not me attempting to offer any advice to people on whether they should register or not. That's just a reading of the language that's on the USCIS website and the AILA websites, respectively. People need to weigh risks and benefits themselves when they are thinking about whether or not they might register. And that's something very separate from what you're going to see written in that sort of language on those web pages.
Got it. Yeah. So it's this old provision of law, right? Like there's been a lot of like bombs waiting to detonate in the immigration laws that were just like already like, wait, what? The law says that people can be deported for their exercise of their free speech? Like what? And I don't agree that the law goes that far, but there are these gray areas of the law that have just been kind of waiting to fall into the wrong hands. And this is one of them, right? And so now USCIS, pursuant to an executive order, is requiring people to register if they aren't already registered through some other proceeding. And the risk of not registering generally is you may be liable for civil penalties or even criminal penalties up to 6 months in jail if you come to the attention of federal law enforcement and they enforce the law against you, right? They say, we're going to penalize you for failing to register. So that's like generally the stakes. And the reason why we were focusing in on, first of all, like who has to register and who doesn't. There are a number of people who, by virtue of having pending immigration matters, already have registered because they're already at the attention of government and the government has their biographic data. And then there are folks who have not yet registered. So kind of pinging back and forth between USCIS's guidance and the American Immigration Lawyers Association's practice advice, and also the American Immigration Council's practice advice. We're going to kind of piece together who this affects and who it doesn't. So to Emma's point, like generally speaking, the regulations highlighted here say who will be considered to have registered already by virtue of their existing immigration matters. So people who already have registered, right? Green card holders, people who had entered with parole, people who had entered with some kind of visa, people who had entered with a green card, people who are in removal proceedings, meaning you've been served with a notice to appear that has been filed with the immigration court and you have a first hearing scheduled or have already presented at least one immigration hearing, right? Active removal proceedings. A person with an EAD, an employment authorization document or permission to work, people who have pending applications for adjustment of status. So in effect, people who have entered irregularly and have not yet come to the attention of government, people who have come to the attention of government during border crossing, but their removal proceedings have not actually started in immigration court, those are the people that the government is requiring to register at this time. Is that a fair summary, Emma?
I think so. The other thing that I would throw in there is people who have come to the attention of government solely through like an affirmative application that has not progressed past a certain point yet.
Right. So if you're applying for, good point, if you're applying for some type of status that is not lawful permanent residence, right, a green card, which is what this form I-485 is, if you're applying for other types of visas, other types of protection or status, then, and that has not been adjudicated and granted, then I agree, Emma, then those folks would also be required to register. So just to summarize, to make sure I'm understanding, we're saying folks who have never come to the attention of government before, maybe entered irregularly, and overstayed, or overstayed. People who were given a notice to appear during their border crossing, but that notice was never served on the court by ICE, and so they're not yet in removal proceedings. Those folks need to register. And people who are not otherwise in removal proceedings and have applications for status pending besides an application for a green card. Those are the classes of folks that are being required to register under this area of the law.
Unless any of those folks have already gotten an employment authorization document through some means, I think that's correct. And definitely, I think important to specify between who the law is stating are required to register and who need to register. I think there's a bit of a difference there.
Yeah, and totally. And I think that our point in recording this discussion is we're not going to be prescriptive about. It's not our position to say who needs to register. There are many folks for whom, like, they might decide that they are going to choose non-compliance. Our ethical duties, as you know, Emma, prevent us from advising anyone to not comply with the law, but we can help people understand the risks and benefits of taking certain legal action or not, so that people can make the best decision for themselves, right?
Absolutely.
So here,
oh, sorry.
Yeah, go ahead. No, go ahead.
I just wanted to ask if we could talk a little bit about children and if children are required to register or not.
So children under 14, right, is the threshold. Immigration law cuts off a child at 14. 14 is when a young person's considered old enough, like competent enough under the legal system to sign their own documents, for example. So yeah, Emma, I don't know if you want to start on that one.
Sorry, when it comes to children?
Yeah,
I think you covered that.
So, well, I mean, so a child is 14 years
Right.
old is the cutoff, right? So the regulation requires that
Individuals
a
14
person
and older.
over 14 is required to register. So would the guardian of a 12-year-old, for example, let's say there was a 12-year-old unaccompanied child who is in the guardianship of a family member in status here in the US, did they need to register?
Yeah, so if we're talking about, as you said, like who must apply for registration, someone who's 12 years old has not yet reached that 14-year-old point. So no, under the text of this law, they're not required to register because they're still have not reached their 14th birthday. The guardian, if all that we know about them is that they have someone with them who's less than 14 years of age, they would also not be required to register. Again, that's if that's all we know about them, is that they're the guardian of that person. We have discussed that there are other things, such as how long they've been in the United States, what their status might be outside of parent or guardian, that could change that qualification.
Liv, are there any other variations of that question you've been hearing in your community that would be helpful to talk through?
I think people are mostly just concerned about like young children, if they're required to register their young children. So their understanding, I think, currently is that if the child is under 14, they do not need to register, but the parents do.
Right. Anyone over 14 is captured by the registration requirement who fits those other categories.
Right. And that's sort of what I was trying to say, is like, if all we know is that they're the parent or guardian of a child who's under 14, that doesn't actually give us enough information that they need to register or not. According to this, we need to know more about that individual and where they are in those other categories that we discussed earlier in the video. And then, I don't know, is it worth also maybe talking through like risk reward factors for individuals who are, you know, still in this, what we might consider children, right? So like I would consider someone like 14 to be a child still, but who according to this need to register.
Yeah, I think that's definitely something a lot of people have questions about.
Yeah. So I think one of the biggest risks that I see when folks are debating compliance or non-compliance, is whether they will be able to provide accurate and truthful answers to all of the questions that are asked during the process of registration. If an individual is contemplating registering, but is contemplating registering and not providing truthful answers to everything that is being asked, I think that's a really big risk. If an individual is considering registering and can provide truthful answers to every question asked, I think it's less of a risk. So that's sort of how I start to think about that factor. When we're looking at potential reward factors, for individuals who already have an application in process or a court proceeding in process, right? They're already at the awareness of the government, or not a court proceeding, sorry, who already have an application in process. For example, for someone who's under 14, say special immigrant juvenile status or asylum, there's the potential that being compliant, that registering, that requiring all of this truthful information could maybe benefit that application. So there's a potential reward there if you're being seen as compliant with other areas of immigration law. And then there's also a potential heightened risk there that if you're seen as non-compliant, it could adversely impact another application that you have in the system. So I think that's what you sort of look at when you're thinking about risks and rewards, both for individuals who are like right at that sort of like tender but not still child age of like maybe 14 to 18, 14 to 21. And I think also can apply more broadly to other individuals thinking about risk and reward factors for registration.
Yeah, I agree. And zooming out to think also about adults, like how people might think about, how they're going to make this choice for themselves. There are potential immigration risks and rewards, right? And then there are also other civil and criminal liability risks and rewards that are contemplated by this program. And so here we've shared the American Immigration Council. They're a very trusted source. Highly recommend their resources. And they, as they point out here, there are civil and criminal liabilities for not registering. And like any prohibited conduct, if you don't fully come to a stop at a stop sign, or you don't pay your taxes accurately and on time, there are lots of things for which the law creates civil and criminal liability that are not necessarily bad in and of themselves. They're just bad because we as a society decided they were. So non-compliance with a form registration, right, or carrying proof of registration on you, which is a second part of the program, you have to register and carry proof, is that if you come into contact with law enforcement and they prioritize enforcement of this law against you, then you may be subject to civil or civil penalties, meaning money fines, or criminal charges, which includes time in jail, which is bad in and of itself, right? But know that the criminal legal system involvement, even for things that are nonviolent or routine, is the surest. That's the biggest risk factor to someone's pathway to removability, right? Yeah. Even a person in status who has certain kinds of criminal legal system involvements can then find themselves removable under immigration law. And for people who are undocumented, having a criminal legal system involvement is typically the easiest way for ICE to become aware that you are here and to prioritize you for removability by virtue of your undocumented status, right? If not having status makes you removable under the immigration law. So it's a matter of, to be crass, the way that someone might think about this is like, what is the likelihood that I will be caught? Right? Not registering and or not carrying around proof of registration. Something that people might want to think about is, what is federal law enforcement presence like in your community? Most of Vermont falls within the 100-mile border zone. We have heard lots of reports of routine traffic stops being set up around the state. So if in a traffic stop, for example, law enforcement asked you for proof of your registration, and you either assert your Fourth Amendment right to not speak to them without an attorney, or you waive your Fourth Amendment right to silence and instead volunteer to say that that you show them what you do or don't have. Understand that that might be a point where you're at risk, right, of enforcement of civil and criminal penalties for not complying with the registration requirement, and or immigration penalties, right, enforcement of removability. On the other hand, for folks who have never handed over any of their information to the federal government, you are now bringing yourself to the attention of the federal government. And that means that if you are removable under the law and ICE wants to prioritize you for enforcement of removability, they'll know how to find you, because you will have told them your address and all your contact info, right, and your employment history. Whether or not the government will be prioritizing registrants for enforcement of removability is a question we don't know the answer to. What we can share with people is that right now in Vermont, the majority of people who are becoming detained and put into removal proceedings and having to fight them from a detained posture are people who have had criminal legal system contacts, or people who are driving too close to the border, to the Canadian border. That's the majority. And so it's hard to imagine that the government would prioritize enforcement of removability for registrants who don't have, who present themselves and say, here's my address, and have never otherwise had contact with legal systems. But we can't predict how the government will prioritize its resources. Now more than ever, we're unable to predict the patterns of how the government is working. So you just to understand that is what's happening, right? You're presenting your information. And to Emma's point, there might be people who have pathways to relief, to protection from removal, who just may not be aware of it, right? If a person has been in the US for 10 or more years and has US citizen or green card holding immediate family members, they might be eligible for something called cancellation of removal. If a person has had bad experiences here in the US or in their country of origin, or they have a reason to fear some back in their country of origin, they might have a claim for asylum or a lesser protection called withholding of removal, right? Or other humanitarian protections. Like there might be opportunities to regularize your status, even if you come to the attention of ICE. ICE decides to prioritize you for removability, and ICE decides to detain you. You still have all of those rights. I think that's like one big message I want to send to the community. I don't know if either of you have anything to add on that point.
No, I think that's really critically important, something that I'm hearing from a lot of people, not just with the registration requirement, but just about like big concerns with how the immigration landscape looks right now, and the fact that it is just really scary and anxiety provoking, is this idea of, am I just going to be like caught up and immediately deported? And the answer is, look, some scary things have happened. There has been some reporting of people being taken from the country very quickly and in very scary ways. However, there are still due process rights, and the vast majority of the time, those are still being upheld as of this moment. It is not a immediate, you come into contact with someone from ICE and you're going to be on a plane out of the country within 2 hours.
Right. So if you have already been ordered removed, and if you have had contact with government after being ordered removed and that order has been reinstated, like if you're in that posture, definitely contact counsel, right? Right now, organizations like ours are prioritizing individualized legal services for people who are most imminently at risk of a quick removal, right? Because that's where we as lawyers can make a positive impact, and make sure that the system, the due process system, works the way it should. But generally speaking, we're not in the position to offer individualized legal advice for people who are not imminently facing removal or people who are not currently detained, unless you're in that specific, a rare position that Emma mentioned. By and large, if you become detained, you can invoke your rights, your due process rights, by expressing any fear of return to your country of origin, if you have one, and asking for an opportunity to speak to a lawyer. Those are the two things that you need to say out loud. You might need to repeat them, but those are the things that you say. And then that triggers a lot of due process, right, to a full and fair hearing under the law. Liv, what other questions are coming up around, like either on this theme or other types of questions we haven't talked about yet?
I think one that came up a lot, particularly yesterday, was if people should be carrying like original copies of proof of registration, or if they should be carrying copies. I think people are afraid to not have the original and be told they're not in compliance versus have the original and then lose that original to an officer.
Yeah, I mean, that's fair. It's hard to predict. So I can only use the information I have now, the best information I have now to give the advice that we can give today. But so far, my sense of the state of the art nationally in conversing with colleagues is that generally speaking, it is reasonable for a person to carry a copy of their proof of registration or their proof of status, rather than an original document that is very difficult and expensive to replace. Know that even if a person becomes detained, let's say that the government in an interaction decides it's insufficient that you're carrying only a copy. The point is you're compliant with the law. And so even if you become detained, a lawyer would, invoke your right to speak to a lawyer, and you should have the opportunity to clarify the misunderstanding that you are in fact registered. But Emma, I'd be curious to hear, particularly in the Immigrant Justice Corps listserv world, if people are sharing other advice.
I don't think that folks have spoken and given advice specifically with regard to the registration requirement, but generally that advice of keep original documents in a safe and secure location, where you know where it is and where someone else knows where it is in case you are detained or in case something else comes up. And then if you decide to carry copies of some form of documentation with you, do just that, carry copies. I think something that's also being stated is that, right, you have this Fourth Amendment right. If you choose to, you do not necessarily have to be carrying things with you, or present those things when asked for them. What you can do is you can invoke that Fourth Amendment right and have someone else sort of take it from there.
Yeah. And the thing to know, this is where it gets tricky, the Fourth Amendment issue, right? Your right to privacy from unreasonable government intrusion. Know that there's also this immigration right that the immigration authorities have to ask people for proof of their status. And so if you invoke your right to silence, which you have the right to do, it is likely that you will be detained, even temporarily, right? But that's why it's so important for folks to know that detention is not deportation, and ICE can hold you in custody. The best practice advice is definitely invoke your right to remain silent. I invoke my right to remain silent. I do not consent to this search. I want to speak to an attorney. And then just understand that it is likely then and this is true in like a road stop, right? If you're being investigated for a criminal legal issue on a highway, then the authorities might exercise their discretion to detain you in that moment on a temporary basis. But then what you're minimizing is the risk that there's anything else that you could say or that the government could see or think that they see on you or on your person, in your car, and your phone that could be incriminating and complicate your legal options down the road.
Yeah, exactly. I think, again, this goes back to what we've been talking about with sort of like risk reward factors and also like just people's level of comfortability. And at the end of the day, these are individual decisions that you have to make for yourself with all the information that you have available to you.
Liv, what else? I know we've definitely surpassed my projected 15-minute time, but that's okay. People can watch this on double speed. Any other questions that have been pressing that we haven't touched on?
I haven't heard any more related to this. We have heard a lot of panic and disquiet about the parole announcement that came out yesterday. So from my understanding, people who entered under CHNV or CBP1 are not required to register because they did enter under parole. But I don't know if oh, sorry, Emma has her hand up.
Yeah, just before we get into the topic of parole, I'd love to state one other thing about the registration requirement. Something that I've seen sort of going around a lot is this idea of like, okay, if registering, when? And that's a really good question. So today, Friday, April 11th, is the day that this sort of policy goes live, as a matter of speaking. And then it's 30 days from that date to register. Something that some communities have been talking about is the fact that there have been injunctions placed on other rules that have come up, other immigration rules thus far, and that it's not out of the realm of question that an injunction could come up here as well. So this is not advice. This is just me sort of stating what folks have been talking about. There is a talking point that it might make sense to hold off, to not register right away at the beginning of April, and sort of wait and see if it looks like an injunction is coming or not. And then pick up this question of whether or not to register again closer to the deadline, which would be towards the beginning of May.
Yeah, great point, Emma. So just to put a fine point, in case folks don't know what an injunction is, when lawyers like us see that the government is doing something that's outside of their power, or they're, abusing their power or doing something that the law says that they can't, we can file a lawsuit, right? And ask the judge, the courts to say, government, stop doing illegal things. And in this case, there is a lawsuit already pending about this registration program. And it may be that a judge, the federal court system decides to say, stop it, don't do this registration program. And so to Emma's point, like, wouldn't it be a shame if a person had rushed to register, brought themselves to the attention of government, shared all this information, and then it turns out the courts say that program is illegal and can't be implemented. So, and just to demystify it, so you can see here on USCIS's website, uncharacteristically, they're requiring online registration. Typically, people have an option of either paper or online registration for accessibility and equity purposes. Here, they're requiring online registration. Why make the program accessible, right? When it carries criminal liability. So it's an online form. So unless you create an online account and actually go in, you can't see the form. So I've just pulled up some of the blogs that I've found that seem credible. I'm familiar with the form G325A, which is a variation of the form that's required for people who are applying for green cards. And so G325R, I could see it being, it asks for similar information. But just to give people a flavor of what might be asked, your name, your alienage, or your country of origin, if you have a registration number already with the department, your address history, your employment history, and information about your spouse. and any immigration history. So it's a lot of information, right? And this is the kind of information that people are required to present when they're applying for immigration benefits or status. So, not to be taken lightly. And if you are interested in figuring out whether you might be eligible for some kind of status, there are resources that we recommend on our website in our community library. Again, that's www.vaap.vt.org. So I'll pull it up. You can go here. You can change the language here in the top right corner. And if you go to the community library, which is missing. Oh, here. The community library is now its own standalone dropdown, and that's how you can learn more about what your immigration situation and options might be. I'm happy to talk about parole now, to Liv's point.
Yeah, I think this is a great time to switch over. I just wanted to get that one more point in before we switch topics.
Totally. So to Liv's point, yes, a person who was paroled into the United States, even if that parole expires, they do not have to register affirmatively, right? They're exempt from that registration requirement. But we are hearing, of course, all over Vermont, people are getting these notices of termination of parole. Emma, can you take us through what is parole? And why is it being terminated?
So parole is a form of sort of temporary allowance of entry into the United States. It's provided for a certain amount of time. When you're given parole, there's an expiration date. There are different forms of parole. Typically, it's about a year. Sometimes it can be a little bit longer. And the expectation is that after that time has expired, you either leave or you've applied for some other form of status, immigration relief benefit that allows you to remain within the United States. So I think something to keep in mind is that, one, the language of these notices is scary and harsh, and that's on purpose. It's meant to cause chaos. It's meant to sow fear. Other than speeding up what someone needs to do when they have parole, it is not actually putting people in a terribly different legal predicament than the one that they were already in, because you still do need to either exit the United States or apply for some other benefit or relief. So this is sort of it's shortening the timeline in a way that's scary and harsh. The reason that it is being terminated is because right now we are seeing a cut down on basically any form of benefit that is subject to discretionary termination, and this is a discretionary benefit. So something for people to keep in mind is that if you receive one of these parole notices and you're thinking, oh my gosh, this is terrifying, it says I have to self-deport right away or I'm going to get in trouble. No, no, you have other rights. You do not have to immediately self-deport. That language is meant there to scare you. It is not there because this is an immediate legal need. What you do need to do is what you already needed to do if you enter with parole, which is seek another form of relief. So that's sort of the main point that I want to drive home to people who are rightfully scared by getting these messages in their inboxes. Jill, I don't know if you have other stuff you want to add there.
Yeah, so common scenarios of questions that I've gotten, and Liv, I'd be curious to hear other scenarios that we don't cover. But one is okay, I entered on parole. I've already applied for asylum. I submitted my asylum application with the government, either with USCIS or if I'm in removal proceedings with an immigration judge. This parole notice, though, says I need to leave. What do I do?
Great, good job. You already applied for asylum. You already have another form of relief pending. So no, you don't. You don't need to leave. You are now permitted to stay here and to adjudicate that asylum application. One thing to think about is that parole does come with an employment authorization document. Once parole is terminated, that is also terminated. So if you have applied for asylum and you are at the 150-day mark where you can submit a free application for a new employment authorization document, this is a great time to do that. But no, you do not immediately have to leave. You do not immediately have to self-deport. You do get to still go through the procedure of your asylum process just as anyone else would be able to.
Yeah, so let's look at that. And to borrow some social work pedagogy, thinking about like Maslow's hierarchy of needs, right? I'm hearing in this conversation clarity that a person does not need to self-deport, even though the letter uses very strong and misleading language and omits proper notice of your options under the law. A person does not need to self-deport, right? They would become undocumented and still have access to the same rights to defend themselves against removal if the government prioritizes them for removability, for enforcement, as they would otherwise. And that is, so we just want to demystify that the fear of that, the ultimate legal harm of deportation is not like this, nothing about this notice or the parole program changes anything about your rights to be safe from some kind of immediate deportation, right? But there is this other legal harm that Emma is naming, and that is a real harm that we want to validate because it has really immediate economic, material consequences for people, right? People will be losing work authorization. And if they don't, to Emma's point, if they didn't already apply for asylum at least 5 months ago and already apply for and receive their work permit, they will be losing work authorization. And right now, employers are facing heightened scrutiny from the Department of Homeland Security doing what's called I-9 checks, meaning DHS shows up to an employer and says, prove to us that you're maintaining accurate records that all of your employees are authorized to work. And so employers are being advised by their lawyers to be diligent about checking people's work authorization. And so people may lose their jobs over this.
Yeah.
And that is really hard. And there are alternatives to earning income. People can, in some cases, volunteer for stipends. In some cases, people can practice their trades as solo practitioners, business owners. There are some types of income earning that is not considered employment, for which you don't need to be employment authorized. But, we do want to acknowledge that that is a harm. And if community members in an allied positionality are wondering how they can help in this moment, mutual aid, community support for people who might lose their income as a result of parole revocation is a great place to focus your energy and resources.
Absolutely.
I think a question we're hearing a lot from people so they can appropriately weigh the risks to them versus exactly the need to work and support themselves and their family is what is the legal risk to them should they choose to continue working with a parole work permit that has now been revoked?
So if a person is presenting, if a person makes any kind of fraudulent or willful misrepresentation about their immigration status for the purpose of getting a benefit under immigration law, like someone's using an expired document or a fake document, or someone else's document or whatever, there can be immigration consequences, adverse immigration consequences. If a person is eligible for and applies for certain kinds of like family or employment-based pathways to status, they can be called inadmissible, and they would have to seek a waiver that is discretionary and expensive and time consuming to pursue and not a guarantee. So your immigration situation can be worsened down the line. That said, humanitarian applicants, like applicants for asylum, do not experience any risk of prejudice on their outcome of their asylum case if they work without authorization. And part of the reason why the law does that is a recognition that humanitarian status seekers often like flee and arrive with nothing and still have rent to pay, right? And so and need material needs to meet. And so the law kind of automatically forgives that kind of conduct, work without authorization or work with willfully misrepresented information. We cannot counsel people to not comply with the law. But I can share that, I'm a humanitarian immigration lawyer, and I have never had a client who wasn't working. And 100% of my clients are not authorized to work when they meet me. So people might, right? Like the risk is future immigration consequences when your employer finds out, if your employer does an I-9 verification process or is scrutinized by the department to check that they're in compliance with the I-9 rules, they might terminate you. And strangely, everyone who works has tax liability. The government contemplates unauthorized work and does require everyone, another requirement like the USCIS registration requirement that people have mixed compliance on, is paying taxes even as an unauthorized worker using an individual tax identification number, an ITIN.
That's super helpful. Thank you both for answering all these questions. I know it's a scary time for people.
Any final words, messages to the community, suggestions, plugs, anything?
So I would just like to make just a point of clarity on this parole termination, which is that I think because parole is used in a few different contexts in immigration law, and covers a number of different groups, there's been some confusion and some worry that's very valid about who might be affected. It's hard to predict who might. So again, I'm just going to kind of state what we know is happening so far. So what we've seen so far is that those who have entered through the CBP1 app, their parole has been terminated, and that date of termination is effective 7 days after receiving that notice. What we have seen for individuals who came in through different forms of parole is that currently CHNV parole has been terminated. That is effective April 24th. We have not yet seen that any other sort of individualized programs like CHNV, that any of those parole statuses have been terminated. There was a letter sent out to some who were here under the Ukraine program that was improperly sent, stating that their parole had been terminated. It was clarified that that was improper. And as of now, all other parole programs are still in effect.
Yeah, and the best defense against the risk of your parole being revoked is to go ahead and take those steps that were already available to you and incumbent on you as a parolee, that a person can, if you, for example, intend to apply for asylum because you have a fear of returning to your country of origin, don't wait, apply. We recognize that the shortage of asylum lawyers nationwide is devastating, and it's incredibly high stakes, and incredibly harmful to try and initiate an asylum proceeding without legal assistance. We at Vermont Asylum Assistance Project are working to set up some additional I-589 asylum filing clinics for parolees who have not yet applied for asylum and want to. And you should follow us online, our socials, subscribe to our newsletter to learn about those opportunities. And know that even if you come to the attention of ICE before you are able to apply for asylum, even after you've applied for asylum, if you come to the attention of ICE and ICE exercises its discretion to put you in immigration detention, know that you have a right to reiterate your fear of returning to your country of origin and to speak to a lawyer. And there are due process rights available to you. Liv, anything else from your community that you want to make sure we touch on?
No, I really appreciate your closing point, because I think that's something a lot of people are understandably freaking out about, because the language of the messages they're receiving are intended to sow that fear and not explain that those rights remain available to them. So I think that's really helpful. Thank you.
I do think it's also worth noting that everyone's getting the same letter. Like, this is a form letter. I think it can feel really targeted because it says like, you must, you should, but it's not addressing you directly. It is a form letter. So yeah.
Yeah, so hang in there, folks. Remember, fear is the strategy, confusion is by design, and we're here with you doing as much as we can to help clarify what's going on and what people's options are. Liv, thank you so much for all the work that you do in Southern Vermont with CASP, and Emma, thank you for being such an amazing attorney.
You, Jill.
Thank you. Yeah, thank you for leading the charge on all of this.
Awesome. Well, folks can let us know, reach out if you have questions or concerns, and we can keep track of those so that we can record more of these if they're helpful and warranted. And otherwise, again, subscribe, vaapvt.org. Thanks. Emma, we were just debriefing on the podcast recording, and there was one more thing we thought of that we wanted to share. So I'll give you the floor on the question of whether someone is at risk of experiencing prejudice for their humanitarian application, for example, application for asylum, if they work without authorization or present false documents.
Yeah, thanks so much. So I didn't think of this before, but then it did just pop into my head that while there's no like statutory language that says that this is allowed, that's allowed to prejudice, there's in fact language that says it shouldn't. Something that I've seen happen, not affirmatively, but in defensive proceedings, is that sometimes working under the table, but more often presenting false documents will get brought up to try to knock credibility of the person. So this idea that you presented a false document, so why should we believe that anything else you say is true? There are plenty of judges who don't take that to heart, who sort of brush it off. There are also some who do listen to it, who do take it a little bit more seriously. So just in my own practice, I have tended to say that working under the table can be less prejudicial than presenting a false document. But again, that's anecdotal and experience-based.
Totally. I think it's a point well taken. I mean, in my practice, I've definitely seen ICE counsel try to impeach people's credibility to prove that they're not a truth teller and shouldn't be believed on their asylum application, using lots of tactics, including the one that you mentioned. And I think one thing to be mindful of is asylum is a very specific form of relief that is available to people who meet a very complicated definition. We educate about that on our website. And a lot of people who apply for asylum will struggle to meet their burden of proof and show that they meet all the elements needed to prove up a case. And so there are folks who may ultimately not have, asylum relief available to them under the statute, right? For whom the immigration law may not provide them with protection or relief from deportation. And they still have a right to exhaust their remedies, exhaust their right of review, right? Their administrative review, judicial review, but may ultimately be looking at an order of deportation that the law can't prevent. And if that is the case, people in that posture, I understand, might make decisions that they need to make to meet their immediate material and safety needs right now, understanding that there could be legal consequences later. So yeah, again, to use Emma's phrasing, it's like that risks and rewards analysis that's unique to every person based on their situation. But thank you for making that point. I really appreciate it.
Yeah, thanks, Jill.
Awesome. Thanks. Bye.